The deceased's family outside of the wife and children don't have title or any entitlement to anything that is part of the Hi guys, welcome again to Mamolao. Here we are again standing on legal business. We are going to discuss wills and estates, what we call in the law intestate and testate succession. Basically, whether or not you have a will and how those processes work. Today, we have invited an esteemed guest, a well-knowledgeable person in the subject matter of wills and estates. His name is Ofentse Rasebitse from Rasebitse Attorneys. Welcome, Ofentse.
Thank you. I am Mamolao.
You are very welcome here. And I really want us to jump straight into it with regards to wills and estates. I think it's something that we take for granted often, and it's something that is really, really, really important, especially as people who need to either, when somebody passes away, you're either on the side of inheriting or you're on the side of administering, right?
True.
And I think it's really, really important that we take our viewers through the processes. So I'm going to set a scene. I think it's important when we get an example, it actually puts us in the picture a little bit more.
Okay.
So we have Thabo Mokoena, who's been married for 15 years to his wife, Sarah, and they have 2 children. Their marriage is in community of property. And Thabo has a child outside of marriage. Both Thabo and Sarah are employed in different companies. And the couple live together in a house worth 600,000.
Okay.
Before getting married, Thabo bought a flat worth 200,000 that he's still paying the bond over. And his wife inherited her parents' house, and that house is worth 800,000 rand. Both Thabo and his wife have debit orders coming off of their account for the house they live in. And the 2 cars they drive, they've got school fees for the children and policies. And then the inevitable happens, Thabo passes away.
Sadly.
So we're at a point where Sarah, his wife, is now a widow. Mm-hmm. She has 2 children and 1 stepchild. And all the other things we've discussed, right? Mm-hmm. In terms of intestate succession, what is intestate succession, and high level, how would Thabo's estate need to be divided based on the assets that we've indicated, or rather the liabilities and the assets that we have just listed?
Okay. All right. Great stuff. Thank you for that, clear background. Also, basically, intestate succession, it's a term that's been derived from another term that we refer to as the right of testation, which basically means a person's right or freedom of will to write their own will and express in the form of a will how they want their assets in the event of their death to be passed on to their descendants, their beneficiaries, if you will. So that right of or freedom to write a will is one that is inherent to every individual. So in the absence of that testation, in the absence of a person having drafted a will before their death, that's when now the term intestate comes in, because it means the person is without that testation, right of testation. Okay. So that's where intestate comes from. So basically it means that because you are without a will, your assets will be divided among your beneficiaries or distributed in accordance with the laws of intestate succession.
Okay.
All right.
Okay. So the law now decides what to do with your assets because you haven't put down your wishes in writing.
Precisely.
Lovely.
Precisely, yeah.
Lovely. So how would Thabo's estate be divided?
Firstly, I must say this is something that happens quite commonly in real life. I've come across those instances before, and it's quite unfortunate. We always try to encourage, to advise people to have their wills drafted,
Correct.
regardless of how young you are, regardless of where you are in life, regardless of how much assets you have, as compared to how much you would want. People tend to think that wills are only
For rich people.
For rich people, for people who have accumulated a certain amount of wealth, which is not true. And a will can be quite broad enough to actually cover even future accumulation of assets.
Okay. So you can write a will for any future assets that you would accumulate.
Definitely,
I see.
And you can even include in there beneficiaries who are not yet born. You can broaden it enough so that even if you should have kids later on in life that were not born at the time that you're drafting the will, they would automatically be included and benefit in accordance with your will. But sorry.
And that's why we probably even have a National Wills Month.
Precisely,
that's how serious
yes.
it is
That's how serious
for
it
us
is.
in this country to
Yes, true.
have wills as individuals. And I think we will discuss sooner why it actually is so important
For sure.
to have that.
Sorry, I digress. Let me get back to
how
your
do we divide
scenario,
this estate?
Tabo's estate. Okay, so interstate succession. So Tabo is married in community of property, firstly, which means that Tabo's assets, in essence, are in what we call a joint estate. A joint estate is what is automatically created when people marry in community of property that is without an antenuptial contract. So
Correct.
joint estate means that all the assets are basically put in what we call maybe one pot, without being owned by either one of the individuals separately. They have equal shares to that joint estate, but they do not actually own the assets individually, regardless of the fact that those assets would have been acquired prior to the marriage in community of property.
Okay.
All right.
Okay.
So by virtue of that community of property and right of 50% share in the joint estate, that is the share that now the law would be focusing on in respect of Tabo's estate, which is now referred to as deceased estate because Tabo is now deceased.
Correct.
All right. Okay. So in the absence of a will, firstly, then in accordance with interstate succession, we look at how whether Tabo was married, and yes, in this instance, Tabo is married, and in what fashion he is married in community of property.
Yep.
Okay. So automatically, because he's married in community of property, 50% of that joint estate, which now obviously has to be divided in accordance with the law of interstate succession as well as deceased estates, is now apportioned to the surviving spouse.
Okay.
Yeah, Tabo's surviving
Okay.
spouse.
Okay.
All right. Which is what is legally due to Tabo's spouse without any, how shall I put it, without any contestation. That is what Tabo's spouse would be entitled to.
Yeah.
Okay.
Nobody
Legally,
can come in
nobody
and
can
disturb
come in and
her
disturb
50%.
that 50%. It's standard. It goes to Tabo's spouse. Okay?
Automatically, because she's married in community
Automatically,
of property.
Because she's married in community of property.
So his sisters and his brothers, they can't come into the house and want to take what they think belongs to their brother.
And it
they
happens.
can't do that. It happens,
no, they can't.
right?
No,
So I think
families
we
have
need to clarify that
Yes.
the deceased family outside of the wife and children don't have title or any entitlement to anything that is part of the deceased estate because he has a wife and children.
Absolutely.
Brilliant.
Absolutely. Yes.
Right? So she gets a 50%.
She gets a 50%. Now we have to deal with Tabo's other 50%. And now because we've already established that Tabo has children, both in marriage and one outside of marriage.
Correct.
Right? Yeah, but the law does not distinguish or discriminate against children born in the marriage or children born outside of the marriage.
Okay.
As long as it is established that the child does actually, or is the biological child of Tabo, then the child has a right of inheritance. All right. So then among those three children then that you referred to, the Tabo's 50% share has to be divided among them.
Okay.
But there's also a catch, despite the fact that Tabo's spouse, sorry, can you give me her name again?
Sarah.
Despite the fact that Sarah has gotten her 50% share of the joint estate, Sarah still also has a share in
The other 50%.
In the other 50%, yes.
Hey?
By way of interstate succession.
Okay,
Yes. Yeah,
okay.
true.
So she gets her 50% in full, But in the other 50%, she still gets a share of
still
that
gets a share.
50% with
Yes.
the children.
With the children.
Okay.
And quite interestingly enough, that term is referred to as a child's portion.
Okay.
Yes, that's the term they use because they divide it among the number of children, and then they include the surviving spouse also among the children to divide it equally. So it's called a child's portion. So Sarah will get, in addition to whatever she's gotten by virtue of a 50% share, will also get a child's portion. However, once again, there's always provisos in law.
Yeah.
It is limited. Sarah's child's portion, or the amount that she is entitled to recover from Tabo's 50% from the joint estate is limited to depending on how big the estate is. But in this instance, I think if we take into account the values of everything there, I don't think it would the child's portion would be in excess of 250,000 rand. So basically what they would do is, there are 3 children, and then they also include Sarah, that would be divided by 4. So we look at the value of the house, but obviously there's also factors to take into consideration, such as whether or not the house is still bonded to the bank, or if it's fully paid off. Because if it is fully paid off, then it is an asset that can be that can form part of the liquidation account that can be distributed among the beneficiaries.
Right.
So we also look at the cash residue. We look at other movable assets that are in there, and the total value of which, after all the debts have been paid, what it would amount to.
Okay.
So for argument's sake, I'm not good with maths with all the figures you gave me for 600, 200.
No worries. You and me both.
Let me just give a very simple, straightforward example. Say, for instance, what is available for distribution after all the debts have been paid off is 1 million. Let's say this is the cash residue in the estate.
Okay.
Then what we would do is we take the 3 children, then we include Sarah in there to divide among the 4 of them. And that now gives us a child's portion of 250,000 rands. Okay. Right. So each one of them will receive 250,000 rands. But fortunately, because the math here works out perfectly, the limit of what Sarah is entitled to would have been that 250,000 rands anyway, because it's kept. Had the child's portion been in excess of 250,000 rands, then Sarah's portion would be limited to that 250,000 rands. It's just a general statute under the Act, Deceased Estates Act, that just limits the amount that the spouse can inherit in addition to their
because
50%
she already
share.
has the 50%.
Because she's already had the 50%.
So in the children's share, her limit is only 250,000.
Yes.
Right?
Yeah.
Even if maybe let's say the estate was worth 1.5 million.
Yes.
Then she would still only get 250,000. And then the balance of that 1.5 then would the 1.2 million would be divided among the 3 children.
Among the 3 children again. That's correct.
Okay. So she doesn't get like a full child's portion.
She doesn't get a full unlimited.
She doesn't get
it has
an
to be
unlimited.
kept. Yeah, it has to be kept. Yes.
I see.
Yeah.
Okay. Brilliant.
So basically that's how it would be divided. And this is in fact the simplicity of intestate succession, that the beneficiaries in this instance, in this scenario, would be the surviving spouse and the children, all known children, be it in marriage or outside of marriage.
Okay, so if he has siblings, he has parents, he has uncles, he has his favorite niece, none of them in terms of this intestate succession are allowed to actually inherit anything.
Precisely.
None of them are even allowed to enter the house and say, this was my brother's favorite what.
No.
He said he's going to give me this
watch.
Nothing
None
of the
whatsoever.
sort.
No family members have any right to inherit anything whatsoever. Not parents, not siblings, not uncles, nobody. Only the wife is recognized by law and the children to be the beneficiaries of an intestate succession.
Okay. And I think at this point, for me, I've actually experienced a lot of the rights of widows not being recognized. This is where really widows have it hard at the point where their partner of 15 years passes on, and now she is left to have to fend for herself, the children, and now there's all these other people who are now entering her marriage space. And now she needs to defend herself. So I think this would also be quite an important discussion for raising awareness about the rights of widows, right?
Yes, yeah,
Widows or widowers, whether it's male or female.
Yeah,
but
true.
The
True. We tend to
surviving
look at it
spouse,
mostly
right? I
on
think
the side of widows, yeah.
we tend to look at more on the side of the surviving female, but also the surviving males go through the same thing, right? And I think it's really, really important that we highlight that.
Yeah.
So tell us, if Thabo was married out of community of property, right?
Yes.
With or without accrual, and maybe you can explain both.
Yeah.
How would the estate be divided?
Okay, awesome stuff. So out of community of property automatically means, as I indicated earlier, that there is no community of property in this instance, which
Right.
means that there is no joint estate.
Okay.
So if there's no joint estate, it means that the parties in marriage are allowed to own their assets individually in their own separate names.
Okay, yes.
Without a right of 50% share in the other's asset.
Okay.
However, in the event of death, for instance, and this is what we're dealing with, in the event of death, when there is a system in that out of community of property referred to as accrual, the accrual system.
Yeah.
It means that at the division of the estate following the death of one of the parties, we have to take into consideration how much the estate or the respective estates of the parties accrued, hence the term accrual, accrued from the time that they were married up until the time that their assets have to be,
Divided.
or shall I say, passed in terms of the laws of succession.
Okay.
So what we do then is we exclude any assets that would have been accumulated or acquired before the start of the marriage. We only look at the assets from the marriage onwards up until the death of one of the two.
Okay.
And we take the values of the two. All right, and then we set off one against the other. So we basically look at which one has accrued more than the other. In this instance, if Thabo's estate had accumulated or accrued more than Sarah's, so say by instance by 400,000 rands, being the difference. That's the 400,000 rands that should be divided now equally between Sarah and Thabo.
Okay, so they each get 200.
They each get 200.
Okay.
Now, this is now obviously in terms of intestate succession. Remember, intestate succession also takes into consideration the rights of beneficiaries' descendants. Biological children that were born of Thabo and Sarah, or any other extramarital children. So in the absence of a will, once again, regardless of the fact that we are now looking at it from the point of out of community of property, in the absence of a will, we still look at intestate succession, or we divide it in accordance with intestate succession.
Okay.
However, this time we must just be mindful of the fact that there will not be division of joint estate. Therefore, the division won't necessarily be 50-50.
Okay.
So Sarah won't necessarily be entitled to, automatically to half of everything that Thabo had
owned.
owned.
Okay.
Yes, it will be in accordance with the calculation of what was accrued.
Okay. But
So-
she will get a portion of whatever was accrued during the marriage.
Yes, and interestingly enough, that portion also is 50% of the value of the accrual, not of the entire estate, but of the value of the accrual. So we still look at, half shares.
Okay, so it's still 50% plus the child's share.
Plus the child's share. Yes, I like you, Mamolao. You catch on
Mamolao is
very quickly.
listening.
Yes, plus the child's portion.
Brilliant.
That's now in terms of the accrual system.
Yeah, out of community of property with accrual. So
that's right.
if we do out of community of property without accrual.
Without accrual,
Yeah.
that's a different story altogether. All right. So without accrual, firstly, then we will look at whether or not Thabo has a will. Okay.
Right.
In terms of that will, Thabo has the right to completely disinherit Sarah and nominate whoever he wants to be the beneficiary. So let us look at two scenarios. If Thabo had a will but was married out of community of property without accrual, and the will states that Sarah is not entitled to anything, unfortunately, then Sarah would not have any right of inheritance in Thabo's estate. But if Thabo did have a will, then it would be up to him what he apportions to Sarah and to any other beneficiary. It's not limited to just the spouse and the children. See, the power of the will is that it gives you the right to divide among your beneficiaries or whoever else you might want to benefit in accordance with what you want.
So in this case, because we are not talking about wills, Sarah gets nothing from this estate, not even a child's portion.
No. Hang on. If we must look at also whether or not there are children or not, which in this instance,
there's 3
there
children,
are children
as there's Sarah, but now they are married out of community of property with no accrual.
Without accrual, which means nothing is accrued.
Yes.
Or nothing can be taken into consideration as having been accrued in the estate, which means that Sarah will not have right of inheritance.
Only the children
will get. Yes,
equal
only the
shares.
If it's intestate, yes, equal shares.
So Sarah won't even be able to benefit despite the fact that they've been married for 15 years.
Absolutely.
And in the beginning, yes, they agreed that it's out of community of property without accrual. For whatever reason, let's say Thabo was into businesses and he didn't want to risk the family structure, etc.
Yes.
She still gets nothing out of his estate.
Nothing. But with the laws, there's always provisos and there's always gray areas. The law always makes the back door open for people who want to come in and claim. But we'll get to that just now.
Okay.
I just want to emphasize.
Because I'm worried about Sarah now.
You're worried about Sarah.
I'm worried about her
We'll get to Sarah just now because there are some things which you highlighted that may be the case, which I feel it's only... it's in the benefit of your viewers to know of. Okay. But let me just finish off by emphasizing that this is the consequence of a marriage out of community of property without accrual.
Okay.
Is that in essence, neither one of the parties or the spouses has a right of inheritance or share in the other person's assets. So it's really by voluntary will whether you want to give anything to the other party or let them share in on what your estate would be. So that would be the sad state of affairs.
I can imagine Sarah would have worked in that marriage. She would have done her part of raising the children in that. Surely there must be some sort of backdoor benefit.
Yes. There is a glimmer of hope, I must say.
Fantastic.
The law is evolving every day. And as you would see in the news, as you would read in the newspapers, online articles every day, that there was such and such a court case where a person applied or made a claim against another deceased person's estate on the basis that they may have contributed or they feel aggrieved that even though they have a marriage regime which excludes them from benefit or sharing in on their estate, that there are some contributions that were made which would justify that person's share in the estate, for instance. So,
surely. So in this case, Sarah contributed to the marriage. She's been there for 15 years. She has raised 2 children.
Has been supportive.
Part-time raised the one outside of marriage. Sarah has worked
has
15
invested
years.
in
She's
Thabo's
invested
business
in
ventures.
Thabo's businesses. She really can prove that there's a monetary value that she's put into the marriage, or there is a value in kind, such as raising children, such as making sure that the home is a home, etc., etc. Surely she has to benefit. Is there any cases that have happened that actually open the door to a Sarah who is out of community of property with no accrual to actually have some level of benefit by virtue of having been the spouse to this person?
Yeah, certainly. There is, as I said, there's a glimmer of hope. Brilliant. But once again, I must just emphasize, it's not an automatic right.
Okay.
Just because you may have contributed, you still have to show good cause why your claim against the state should be upheld or should be, favored or made in favor of you. And this is a court process.
So now it's not automatic that Sarah's going to say, listen, 15 years of marriage, I went through a lot, I've contributed a lot, I want something. She actually has to apply to court to actually prove that there is some level.
And lay a basis.
The rights of widows.
The rights of widows.
The rights of widows.
Okay. That's why it's important to have things such as antenuptial contracts, which are very clear on how things should be divided in the event of, one of the parties passing away.
Okay.
But just also to give a brief summary of how that process would unfold, Sarah would have to approach a court, which would be done through a lawyer, to say, look, I feel that I'm entitled to a certain portion of Thabo's estate by virtue of having invested this and that and that and that. Acknowledge that it's worth this much, and the children should get a larger portion of it. But I feel, and I substantiate with such and such reasons, that I'm entitled to at least 20%. And you have to obviously adduce the proof to the court as well.
Correct.
That this is the meaningful contribution you made in Tabo's estate, and by virtue thereof you are entitled. Then the court will make a decision. And the court are these days actually quite open-minded to that. There have been cases before, be it in divorces, be it in deceased estates, and be it also in customary marriage disputes relating to estates.
Right. Okay.
Yeah,
okay.
the law is actually quite reasonable enough to listen to the other party.
Okay.
Despite that, where the statutes or the acts or the laws that govern deceased estates might be black and white to say no, you're not entitled. But now, common sense.
Yeah, if you bring forward your particular circumstances.
Yes, where
to
justice
prove that, listen, this is actually what I feel like I'm entitled to because this is the evidence that I'm putting forward.
Yeah.
Then the court is willing to listen to your case.
Yes.
And if your case is strong enough,
If it's
then
solid.
they will be able to also divide whatever percentage that has been agreed upon.
True.
Okay.
Yes.
At least that's some sort of, solution
Yeah.
to as opposed to completely not having
at all.
anything. So
Yes.
I think if people then maybe signed their antenuptial contract without accrual, out of community of property without accrual, and long ago they didn't know Mamolao was there they didn't know that this level of information actually exists, and they didn't even know that, per your example, that in your antenuptial contract, you can actually write, in the event of death of one of us, this is how then it needs to be divided. That way, it's clear at the point of death, you don't have to go around proving your case to a court of law. It's already in the contract, right?
Precisely.
But if it's not in the contract and you signed it before knowing this level of information, you can still apply to court to get it, to make a decision around whether or not you should be entitled to this. You can imagine if Tabo has a big business and it's doing well and you've been contributing to it in one way or another, and then boom, you get nothing after that. No.
That
please.
would be unjust.
No,
that
we
would
need
be unjust.
we need to fix the rights of widows.
Yes.
One video at a time, we need to fix the rights of widows.
Absolutely, because the law is there to give effect to justice. It's about serving justice.
That's true.
It will look at the effects of the matter objectively and apply its mind in that.
Correct.
Yeah, so the law is not completely shut.
I guess the legislation itself will also then not nitpick the various types of examples around if we built a business together or if we invested in this and this together. They don't look at that. No. So you do have an option and a right constitutionally to go to approach a court and prove your side of the story.
True.
That is brilliant. Yo, guys, widows, I'm with you all the way. So if in Tabo's case, how would then the debt be paid off? And maybe then we need to discuss the process of how his estate would be administered. Who would need to administer it? What does administration look like? And what is the process of getting those debts paid so that we can get that R1 million that we can divide with everybody?
Yeah, that's true. And that's a very important factor to highlight there, because it's easy to say how Tabo's estate will be divided. It's another thing practically to give effect to that.
Correct.
So what would happen in practice is that an executor of deceased estates would have to be appointed in order to take the affairs of Tabo's deceased estates and give effect to how it's going to be divided.
Okay.
Now, right, in this instance, we are dealing with intestate succession, right? Meaning that there would not have been an executor appointed in terms of a will. So one has to be appointed manually. Manually, meaning that has to be chosen by either the beneficiaries of the estate or the surviving spouse. Preference has been given in most cases to the surviving spouse to be appointed as the executor. However, the right to choose anybody else still rests with them if it's supported by other beneficiaries. So if Sarah is not appointed as the executor, and it's actually quite a technical and legal process that Sarah might want to actually have an attorney take care of all those
Okay.
official tasks. So it is recommended that an executor should be somebody who is knowledgeable in the law. And in fact, in some instances where an estate is worth a certain amount, over 250,000 rents, if I'm not mistaken, the amounts are always shifting. But last I checked, if the threshold is that if the estate is worth at least a minimum of 250,000 rents,
Yeah.
going up, there has to be an executor who's appointed and who should be appointed by an attorney, if not being an attorney themselves.
Okay.
All right. Okay. So the executor of the state, sorry, did I interrupt you there? Let me just quickly wrap up the executor. The executor of the state will then need to be approved by the master of the high court and will be issued with a letter of executorship giving him powers to take charge of the deceased estate.
Okay. So where would I find the master of the high court? Let's say really, I really am Sarah and I've never experienced this kind of thing before.
Yeah.
Where would I need to go on that Monday morning after we bury my husband? Where do I find a master of the high court?
Yeah, true. And that can be quite a very difficult time during a widow or a widower's, life. And finding the court would be, or the master of the high court would be the last thing on your mind when you are grieving.
Correct.
So if you do not know if any attorneys that can assist with approaching your local office of the master of the high court, then you can go to, depending on which province you are in, obviously, whether it be a province that has a high court or a magistrate's court, you can approach either one of those two courts to start with. Okay. That will be the starting point.
Okay.
Because there isn't always a master's office appointed in each and every town or each and every office, but there should at least be a magistrate's court or a high court nearby.
Okay.
And then once you go to your nearest magistrate's court or high court, then they will direct you to the nearest master of or office of the master of the high court who serves for the jurisdiction of that
Where you are.
or where you are of that area.
Okay.
There are some courts who are also empowered to deal with deceased estates that are worth less than 250,000 rents. In which case, what you would need is just a simple letter of authority. You wouldn't need an executor to be appointed. Then they would be able to assist you. But strictly speaking, and for the purpose of this discussion, then you approach your nearest court if you don't know where the office of the master of the high court is, and they will direct you to the relevant office of the master of the high court.
Oh, then that's easy enough. I think it's a good start.
It's a good start. But I'm just making it broad enough to cover just about whatever place Sarah would be, or town or province.
She could be in a remote village where she needs to take two taxis to get to the nearest town. But at least if she can know to at least go to a court in town, I think most people know where court is. And then once she gets to court, she can ask about, I need a master of the high court.
Whereas in Pretoria, in Johannesburg, those are very big two towns. You will not struggle to go directly to an office of the master of the high court or to be directed. So,
correct.
Whereas in other towns, it can be quite a challenge.
That's all we have for this segment. Thank you for tuning in to Mamolao. Please don't forget to subscribe and click on the notification bell for more of this educational legal content. Make sure that you comment, guys. I want to hear from you. And also ask questions because I want to hear those too.